What purpose? Admission matter.
Admission.
Admission matter, you take a date in April. 27th April.
Mine.
27th April.
27th.
April. Urgency. Then 10th April. 10th. First week, we are giving you almost in the first week. Have you done 10th? 10th April. 10th April. 10th April.
Plus, 10, 10 and 11 file additional evidence by the
Why are you bringing it today? For the other side. Tenth of April. Early we done you all the stuff in the. Therefore, we are giving you dates where the lesser number of matters are there.
Yeah.
10th of April.
Please, Your Lordship. In item number 9, Your Lordship, please pass over 14 days. Because, Lordship, I have filed the respondent number. I have filed another read petition. Maybe check with that. Read petition. That
For
petition
the-
number 1 to 18.
Who's for the petitioner? Any objection? Submitted by Mr. A.R. Shrom, counsel for respondent 5, that another writ petition has been filed. The matter. By the same petitioner.
By the respondent number 5.
By the respondent number 5. Arising relating to the same issue.
Lord.
Relating to the same issue, therefore, submitted the April, 20 April.
Last week of April.
Last week of April. Then have it in March, May.
Lordship.
I passed on 9th November. One the doctor was transferred from the air. Directed the office. If you have filed it, have you filed it? Yes, sir. Item? Third. If you order passed earlier, we continue. What What is the matter about? When did you file it?
Yesterday.
Come on Monday. Why the tearing hurry?
Monday then, my lord.
Yeah, Monday.
I'm sorry. My case is covered. Some time may be granted. Fine. But here, my lord, the item number 1, the arbitration proceeding is pending for 3 years. Item number 2, arbitration proceeding is pending for the last 11 years. So they
You
are
file it, we'll close it. When can you file it?
taken up on 10th. Okay. Then I will
We'll hear you on that.
But my lord, I have given my lord document as a I have given the reference, my lord.
You send it by email and the list. You furnish the list of the judgment.
Yeah, and even list also.
But you have to just for what purpose?
Also supply the my lord, the purpose is, my lord, here in this case, my lord, already arbitration
Have you furnished the copies to the petitioner?
No, my lord.
I'll can you give it the copy, then argue the matter. Then for? But the matter has to be heard again.
Yes.
And have it on 9th
9th April. 9th April. Yes.
9th April. So 9th April. Exactly 2 by the council. Submitted by that other judgment. Right. Ninth is a holiday.
My lord, election.
Mentioning on whose behalf. Timing after some time. Yes, we had heard it. But the matter is at the stage of so-called reply. Right? You can urge to the authority in your reply. can't preempt an authority from maybe correct, maybe incorrect, maybe contrary. It have to be dealt with by the authority itself. Right? Right. Passed by persuade or impress the authority, then it lies only in the beyond that you can't do it. And in the present proceeding, then without without that authority first examining the matter, it is possible that they may accept your submissions and close it. Confirmed, then relying on the fact that no, this can't be done because judgment final no. They got to be on the basis of a particular judgment of the Supreme Court. Say that where there is forgery, illegality, whatever. There is a recent judgment of the judgment that the angle of like the least and serve them copies so that they are also aware of the judgment. But approved by the committee. You are the liquidator. You are the liquidator. So we are vexed. We are troubled with the issue that once a liquidation is ordered, allowing you to proceed for arbitration will prolong the process of liquidation. Seven millimeter of this without the POC minus of meeting that is required. Where is the minus of meeting? This is the one. Can you bring it on record? Bring it on record. Where is that? Where is the item? 11 minutes. Is the cost analysis. 11. Page 11. Cost analysis pursuing arbitration. All the four arbitrations are mentioned one by one. Last month, the liquidator declared an SCC. Now, there was some disagreement as I can see in page number 25. Yes, sir. There was. But the clause C. That everything is complete. Anything, payment to the employees, etc. Whatever. Not much. One minute. Tell me. On this one. synopsis of your argument. Hold on. Synopsis of argument. I thought it was there already. And you have to indicate file number here from where you have given the extract. Not really we call for the records, but instead of the records, you can indicate the file numbers from where you have given these extract so that we record it here. Or you give the original file to. There must be some cataloging of these minutes in. There must be some official, must have in the committee of creditors decisions, pursuant which led to the winding up of the liquidation of the company. These must have been placed before NCLT. What I'm saying is, liquidation order is passed prior to a decision taken by the committee of creditors, right? That the resolution proposal has failed, etc., etc. Right. So you must have placed the minutes or something before the NCLT. I know. What we are saying is that, see, that's the reason why we asked you whether you'd like to bring it on record by way of an affidavit, because then it becomes a record. But if it is confidential, then you may like to at least produce the original or give an indication of the records from where you have extracted it. That's all, so that it goes into the order, right? So, yes, Mr. Counsel for the respondent, is it? That will deal with it. If you want to submit your written argument, you can do so. On 2nd of April. File the our by 2nd of April, not last week, it was 2nd week of September. All right. Then 7th, then 7th April. Mr. Kal. Write something.
Since lots of declined to file the affidavit.
We declined your prayer. I don't think.
No, lots of has stated that first, get the instruction, then only.
Finance is regretted. Finance is declined.
Well, yes, that is, I'm just getting to see it now. But that is the same thing that they have been doing. That is why the repetition was filed.
So therefore, you have to call out your rights to say that you are entitled to this device pay, when according to the finance, there is no specific advisory to that extent.
Yes. So, my submissions would then be in the line of the fact that by basically, the corporation is a statutory organization, so to say. Although it's a society, but it derives its origin from the Seeds Act. And as per the provisions of the Seeds Act, it has been created by the state.
There is no question of the fact is that you are not a government servant. Your employees are not government servants, unless you can show that they are government servants, so therefore, no specific recommendation is necessary.
Therefore, possibly it will have to be looked into from the perspective whether the kind of assistance that the corporation has been getting from the state are in the nature of grant-in-aid. If it is in the nature of grant-in-aid, then the question will require Milord's consideration will be whether the grant-in-aid can be unilaterally stopped after having been continued for so long since inception, and secondly, whether this omission in the mentioning of the name in the schedule of the pay rules, that can create a bar on the state.
Grants in aid are not stopped, I think. Grants in aid, they have declined to give you grants in aid in respect of 7 pay commission.
Yes, then
They're willing to give you as per 6 pay.
now there has to be some intelligible difference here. Because otherwise, if the consistent practice and the past practices are concerned, then right from the inception they have been paying it only at par at the rate of the salaries payable to the government employees. In fact, some of the employees of the corporation were also from the state government at the distant past. Now, of course, there are only 2 or 3 maybe. I'll have to check, but
In your second point, which is the paragraph number 4, say the salaries were paid in 7 pay commission from of governing body. Now, how the salary was released without concurrence of the finance that time?
That time, Lordship, that was a mistake. Subsequently, during the pendency,
Mistake. If it is a mistake, then the officers concerned will have to be hold up. How can they allow royal of pay under 7th pay only post facto approval of governing body? When according to you, they are not government servants, therefore, unless there is a specific mention, the recommendation.
that came into light during the pendency of this proceeding, and inquiry has been made. Now, Lordship, the stage of recovery from is initiated. And Lordship, here the granting aid is in respect of those posts at the time of inception were created by the government, and it was expanded up to 114 posts. Now at present, there are only 11 persons who were regularly recruited by the agency, not by the government, and some are in attachment basis. For those 11 posts, granting aid proportionate to the pay commission as reflected in the instruction that has been paid subject to the
So tell us one thing, the structure of the organization. Initially, they were officers drawn from the state department.
Yes.
They were put there. They must have worked for some time. Then there perhaps was a option given whether you'd like to go back or be absorbed.
Some of the officers were given, they have availed that option. Others from the parent department, they got the pension. So, and out of the posts created, some were recruited by the agency.
Right. Now, insofar as these instructions that you have received, 7 pay commission, they have received from are in respect of which employees? All employees or only those employees?
Lordship, only those employees working against the government created post. Because the contractual employees, they get the salary from the corpus fund that was given from the accumulated interest.
Then why do you say that there is a mistake that the amount was wrongly?
Because
Seven pay commission.
because it was the governing body approved, because whatever amount they get, the excess, they will have to get it from their own source to give to implement the 7 pay commission recommendation. But which the authority at the higher level, that is agriculture and the finance, logic, initially there was a mistake. They didn't look into it. When they realized it, logic, it was wrong.
Not clear. You have to give us the reason how it was approved there from 16 to 18 on what consideration? Get it from the record. That is therein lies the hinges the solution. Not given to all the employees, they are not entitled. Unless they can show that no, under normal conditions, the recommendations made to by the pay commission available to government, the benefits should also be granted to the public sector. That again require a further interpretation of an existing constitution. It says that you are entitled to give benefits for required by the public sector.
It's an agency created under a statute. It's a statutory agency, and of a statutory agency created by the state government.
Make it a part of the state.
Why not the nature of control that the government has?
Nature of control is different. That does not make the employees
So
put
they
the
do
employees
not,
at the level of
they
state
do
government.
not per se become government servants. They
That's
do
right.
not per se become government servants. I am not saying that. But what I am on is, my lord, right from the inception of the agency till the time on the day, my lord, entire exercise is being undertaken at the behest of the government, because the fund is allocated by the state. The agency has no means to generate its own fund.
Now let us take it that what your submission is correct, that the by the state, including higher pay. But there is a bar for the government to say that all right, now we can't give you higher pay. Are they under a binding to
No, my
give you
lord.
higher pay for all time to come?
My lord, the creation was with the, my lord, your lordship, if I just can refer the section 8 of the Seeds Act, my lord. That is the basis of the just one sentence, just in one sentence. State government or the central government, in consultation with the government, by notification in the official gazette, establish a certification agency to carry out the functions entrusted to the certification agency by or under this act. The purpose was to carry out the function of the act, function of the state, on behalf of the state, rather, carry out the functions entrusted with regard to certification under this act. And with that objective in mind, Lord, the agency was created by the state with its own employees. In course of time, over a period of time, some other employees had joined or or they were recruited by the agency, that's a different. But the genesis of the agency is behind this on this statutory prescription. And right from 1985, the instructions also say to that extent. As far as this fourth paragraph is concerned, I am not very sure because that will require some information. But they say that it was done on post facto approval of the.
What are the who are the employees? What are the categories of employees? The petitioner is how many petitioners are here?
There are altogether 33.
Now, where are they employed?
Not 33.
They're
number.
employed as what?
That is, of course, not very clear from the pleading.
These petitioners, they are not members of the board.
No,
They are employees under the board.
employees under the board.
What are they?
That I'll have to ascertain because today some little handicap will have the instructing counsel is absent because of the.
Right. There is such thing as a cadre or employees to be appointed, nothing like that. The board is appointed by the central government, chairman, 8 persons, and 1 person by the state.
Yes. Now the composition of this seat corporation, Assam seat, that is on page 15. Page 15 of the writ petition, you will not be to find the composition of it.
The petitioners are not board members.
Are not board members. They are not board
They are
members.
not board members. Now,
But-
in what capacity are they employed? Because the act does not per se have any cadre or any provision permitting the board make necessary appointment.
That's why I'm not initially it was the state government employees who are put under the agency.
No, employees in what capacity? There is one, there are members of the board, then there is a seed analyst and seed inspectors.
Yes.
Get your instructions to the. That title to be paid their salary. A question arose as to whether capacity in which submit the Act for 19. 2026. Assam State.
Seventh April.
Affidavit you filed today.
No, the last occasion, Lordship, I submitted that how this post has come into existence, how this post was created, that I'll be explaining. Now, on the basis of existing records only, I have saying that. It's not the new facts have been added.
So, but some affidavit was filed today.
Stating that how this new post has stood created.
So the question is, why is it filed today when the matter is already fixed? It should have been filed a couple of days back.
I'm sorry, Lordship, it was filed yesterday, but you got that records. All that.
We would also like to go through the affidavit and properly and understand what is.
Take up on.
The copy, is there any
No.
reply, rejoinder that you want to file? No.
Oh, but I can make out any head or tail of the meeting. Same fact.
Permit affidavit to be brought on record like this.
Understood.
Ongoing maternal.
But not the way you must instruct your colleagues on your right. That in a pending matter, you have to take permission of the court to bring on additional action. Not taken it, at least don't bring it on record of a. So like you would, because it was not there yesterday.
But take up this letter on Monday next then.
You can have it on. Second April, can we have it?
Got you.
2nd April.
Can we have it on 31st, madam? 31st of March.
Second, we have only.
Sorry, Lordship. I didn't know.
You don't have to be sorry. You did not file it. It is your advocate on record who has filed it. He has to be told about the practice that followed
That
in
is
the
also
Pahar.
comes to me back. My fault.
Don't mean anything to you. All
No,
I'm
yeah,
saying is that just some time to reflect on what you have filed and understand and digest.
Second, any case, madam, by filing an affidavit,
That will decide. 2nd of April.
Possibly.
Why do you file it on the eve of the matter being fixed?
Actually,
Whatever it may be,
first week of April.
it's a matter.
Availing there's a interim order. That is why this tactic Malot. Can it be my next week Malot? The urgency because they were transferred next
it is 26. It is taken by the council for the certain affidavit, additional affidavit. By the
There was to collect in, but the honorable both is passed. They have filed only the affidavit that they are marks only the petitioner's marks on.
what test is it? Grade 3 non-technical.
Yes, minor.
Why were they not selected? Stand of the evidence. Yeah.
Skill test, my lord. Just a minor. Marks was given by pencil. I or
These marks were published.
yes, yes, yes.
By the director of medical education. But that instructions by way of an external. Cut-off mark of the petitioner
are less than the, Lordship, the petitioner has scored the cutoff mark. At page 67, Lordship, it is the instruction. Here the general candidate male person, Lordship, he got, the last selected candidate got 108 marks. Whereas all these petitioner, Lordship, they have secured, Lordship, total marks out of 120, Lordship. The one petitioner got, Lordship, 106, 103 and 102. That's why their candidate now is paying for following the report.
So what is stand in the affidavit that you have reflected? That they have not scored the required marks?
Yes, Lordship. At page 7, Lordship.
Some of the numbers were inadvertently omitted.
Yes, Lordship, that was, Lordship, prior only, Lordship, prior to the skill test, Lordship, for which we have again published, we have added few roll numbers. Some technical error. Thereafter, Lordship, those roll numbers were Lordship, added to this list and Lordship added for
Was the records in supporting your paragraph number 8 statement?
yes, Lordship,
Para 8 statement?
that the roll numbers were, yes, Lordship. Yes,
Where is the inadvertently and who has taken the decision?
and then group C, 13 and 20.
Number 6 and 7.
Yes,
Fine? Is the skill test?
yes, ma'am.
How do you know 98?
Lordship, they secured
Written
90.
exam we have
That
got-
was the fact.
we have got.
What is the skill test?
Skill test, Lordship, document verification is skill test. Lordship, that I can get the instruction, what skill test was.
Your affidavit is there on record. Why do you want to keep on going back to instructions? What is the point in filing an
They
affidavit?
have not written.
That skill test was conducted, Lordship.
What is the skill test? What skill are you testing?
Lordship, particular to that food, Lordship, laboratory. That document verification and.
What skill test did you appear for?
Computer exam, my lord, we have asked for. Number one is to prepare a chart of all the medical college in Upper Assam in MS1.
2 weeks. Yes, let him produce the report. What skill test? Computer test?
Yes, my lord. I'm mentioning in paragraph 5, my lord. The petitioner number 2 and 3 were assigned to prepare tabulation of marks obtained by the candidate in their different subject in tabulation in Excel. That's this was the skill test.
First case, what did you pray?
And in the first case, only pension.
What is the status of that case?
Was listed yesterday, my lord, and fixed after 2 weeks for filing of their activity. So let the both the cases.
By the council. Early filed direction. That 97. Prayer made is not objected, but file. They have not filed. Respondents, they will endeavor to file their affidavit. Yes.
Kindly
Heard this matter. Multiple so calls.
Multiple. Judgment I have provided.
Paragraph.
Paragraph 16 or 17. Diary number 6.
Give us the order. Take us, give us the order.
This is the order which is passed by the Delhi High Court and Supreme Court, and
that is
SEC has approved the Supreme Court, and Supreme Court dismissed the. Kindly take up the matter. Regarding the
They've already heard you. That's the only issue. If there's any further judgment, you please take before the court. File any judgment that you heard. Is there a bar that I can't close hear the matter? Then why are you making the submission repeatedly? Heard, sir.
much of it.
Please judgment if you have. Give it to the court master. 2015 matter,
My lord.
11 years.
What the
What's the prayer here?
my prayer is that the less payment of the pension.
For oil.
Well, I am a bit
Yeah. are complete here.
Or is a case where he is asking for ex gratia of rupees 400. He added to his
And he's fighting you for like 11 years.
plus 11. Basically, he is getting his pension. He is only eyeing an extra apple in the garden. That's it.
When do you want it? Second of
The last occasion I was directed to obtain instruction, specific instruction, Lordship, as regards the appointment of the employees of the State Social Welfare Board. The rules, my lord, are annexed. Also available in the writ petition as well.
so what board? Board.
Assam State Social Welfare Board.
Okay.
Lordship, now that board has been dissolved, the Central Social Welfare Board has also been dissolved. The employees have drawn their CPF, leave encashment, gratuity leave.
What is their prayer now before the court?
They want their pensionary benefits.
Arbitration appointment. What? Where is the argument? Where is the agreement?
Agreement is in case of a
Yeah.
Clause 42. The arbitration clause.
The agreement, date of agreement.
No, I'm sorry. Clause number.
Clause 42. It's good that you, where is your notice? Under 21? Where is your, where is the other side?
Class is code number 1.
Where is Mr. Pathak?
Please. The code number 1 of the
Both parties are there. Is he available to come now? Pass it over for the day. Next week. Come. Next week. Not cheaper. Keep your. I'm
similar order.
Matters are pending somewhere, pending before a division bench. What that bench? Is there any stay or is there any direction that all matters to be cannot be heard or anything like that? Then how? Why are you making reference to this? How matters? Have anything been authoritatively decided as on today? Binding on this court?